New York provides a hospitable environment for litigation finance. New York courts recognize the doctrine of champerty, but they only apply it to prevent third parties from instigating litigation by others, not to prevent third parties from funding ongoing litigation. In addition, the state's Attorney General has worked with the Litigation Funding Industry Association to create a set of guidelines for litigation funding agreements that will make them presumptively lawful. Litigation funding in New York is directly regulated by a kind of consent decree between the American Litigation Funding Association, ALFA, and the New York Attorney General. ALFA has an agreement with the Attorney General entitled Assurance of Discontinuance Pursuant to Executive Law. This agreement establishes the conditions under which lawful litigation finance agreements in New York can be drafted. Under the assurance, the 9 original ALFA members promised to draft litigation financing agreements that disclose annual interest rates, itemize and describe any one-time fees, and include 36-month repayment schedules broken down into 6-month intervals. ALFA's members also pledged to allow consumers a 5-day cooling-off period to terminate the agreement, as well as to conspicuously advise consumers to consult legal representation prior to signing. Apart from the regulatory effect of the assurance, New York law does not recognize champerty and specifically permits the assignment of the proceeds of a litigation claim. Moreover, New York courts have specifically held that litigation financing agreements are enforceable. In the case of Echeverria versus Estate of Lindner, the court pointed out the common law of champerty has been codified in New York under judiciary law, mainly sections 488 and 489. Champerty prohibits any attorney, person, co-partnership, or corporation from directly or indirectly taking assignment with the intent and for the purpose of bringing an action or proceeding thereon. In order to constitute champerty in New York law, the primary purpose of the purchase must be to bring suit or proceed with action upon the claim they received. The case law interpreting these statutes recognizes a distinction between the assignment of the claim and the assignment of the proceeds of a claim. Because a litigation financing agreement does not give the funder the right to litigate the claim, such an agreement cannot be voided as champertous under New York law. If you need help with litigation funding, call or email me today.